Today, we're unearthing a piece of legislation that really touches our everyday lives, often without us even realizing it. We're talking about the Anti-social Behaviour Crime and Policing Acts of 2014.
That's the one.
If you've ever dealt with, say, a noisy neighbor, seen graffiti pop up in your community, or worried about an out-of-control dog, then this deep dive is definitely for you.
Absolutely.
It's all about how the law steps in to tackle those day-to-day irritations that, let's be honest, can really bring down the quality of life.
Exactly. This act, which came into force back in March 2014, it sets out a pretty robust framework. It gives authorities new powers to address a surprising range of issues.
Right.
Ultimately, it's about empowering communities and agencies to improve local living.
Our mission today isn't to dissect the entire sprawling act, because it's huge.
It is.
But rather to take a crucial deep dive into one of its core, most frequently used tools, the Community Protection Notice, or CPN.
Yes, the CPN.
Yeah.
Very important.
We'll explore who can issue them, who might receive one, what they can demand, and, crucially, what really happens if they're ignored. Get ready for some practical insights and perhaps a few surprising facts that might change how you view local order. So let's kick things off by defining our terms. What exactly are we talking about when we say antisocial behavior?
It feels
That's a pretty broad umbrella, right?
It absolutely is, yeah. The Act uses it to describe a whole spectrum of incidents, from something as simple as persistent littering or vandalism,
Okay.
right through to public drunkenness, aggressive dogs, or those neighbors whose parties just never seem to end.
We've all been there.
Exactly. It's designed to cover those persistent nuisances and disorders that chip away at community well-being. We can maybe think of it in three big categories.
So what?
There's personal antisocial behavior, which targets a specific individual or group. Then nuisance behavior, which causes general trouble or annoyance to a community. And finally, environmental behavior, which impacts wider public spaces or buildings. It's quite a holistic view of community impact, really.
That helps paint a clearer picture of what falls under that umbrella. Now, for the star of our show today, the Community Protection Notice, or CPN.
Ah, yes.
This is found in a specific section of the Act. It's a pretty powerful tool, isn't it? What is it, and who actually has the power to issue one?
Well, a CPN is essentially a legal demand. It imposes specific requirements on an individual or even an organization.
Okay.
It's a key frontline tool for local authorities and the police to deal with these ongoing community issues. When we talk about authorized persons who can issue these,
Yes.
we're typically looking at police officers. Local authority officers think you're council workers.
Right, like council staff.
Exactly. And in some very specific cases, social housing landlords also have this power.
Interesting. So when can one of these notices actually be issued? There must be some very clear lines that have to be crossed before a CPN lands on someone's doorstep.
That's right. The law sets out two crucial conditions that must be met. No ambiguity.
Okay, what are they?
First, the conduct has to be having a detrimental effect on the quality of life of people in that area. And this effect needs to be persistent or continuing.
So not just a one-off party.
Exactly. Persistent or continuing. And second, the conduct itself has to be deemed unreasonable.
Unreasonable. Okay.
If those two conditions are met, then a CPN can be issued. The notice itself can then demand a few types of action. You might be told to stop doing something specific, like playing loud music.
Stop the noise.
Or do something specific, like cleaning up graffiti.
Take action.
Or even take reasonable steps to achieve a result, such as getting your dogs barking under control.
Right, so it's quite flexible in what it asks.
It has to be, to fit the situation.
Let's see how this works with a real-world type of scenario. We're drawing this from one of our sources, Urban Canvas. Imagine Maple Avenue, right? Residents there are constantly bothered by late-night noise spraying, hammering coming from Urban Canvas, a community art project run by a registered charity.
Ah, okay. So a potentially good cause, but causing issues.
Exactly. This happens several times a week, disrupting sleep. Plus, discarded art materials are piling up by their front gate, creating an eyesore and an obstruction.
Right, not ideal.
So PC Adams, a local officer, investigates. He believes this conduct is both unreasonable and detrimental, so he issues a CPN directly to Urban Canvas, the charity itself.
Oh, the organization, okay.
The notice requires the charity to, 1, stop making noise audible to neighbors after 9 p.m. daily, 2, set up a contained storage area for waste art materials within 7 days.
Right, practical steps.
And 3, take reasonable steps to minimize noise escaping the workshop during permitted hours.
Okay, so in this case, PC Adams has clearly met those initial legal grounds. The noise and rubbish were persistent, detrimental to local quality of life, and you could argue certainly unreasonable. And the beauty of the CPN requirements here is how they tackle different aspects. Stopping noise is a stop doing demand.
Yep.
Creating a storage area is a do specified things action.
Makes sense.
And minimizing noise generally is about taking reasonable steps. What's particularly interesting is the recipient here. Urban Canvas is a charity, a body, as the Act calls it.
Right.
And perfectly valid to receive a CPN, regardless of the age of its individual volunteers, even if some are 15, like in the source. It's a great example of how these notices bridge the gap between community issues and legal enforcement.
It often forces a balance, doesn't it? Between, say, a charity's good intentions and the impact on local residents.
Absolutely. It's a fine line to walk, ensuring compliance without stifling valuable community efforts. That balance is key.
Now, it's not just about meeting those initial conditions for a CPN. The demands within the notice itself also have to pass a reasonableness test.
Oh, absolutely crucial, yes.
This is a really important safeguard, I think.
It truly is. This part of the law, Section 43, subsection 4, ensures CPNs are proportionate and fair.
So what does that mean in practice?
It means the requirements laid out can only be those that are reasonable to impose, specifically to either prevent the detrimental effect from continuing or recurring, or to reduce that effect.
Okay.
So this raises an important question. Are the demands directly addressing the problem, or are they excessive? It promotes fairness and prevents overly burdensome restrictions.
So the reasonableness test is the law's way of preventing overreach.
Exactly. It's not just about a problem existing. The solution imposed must be proportionate. This often becomes the central argument in appeals, you see.
Right.
It shows that the intent to fix an issue isn't enough. The method really matters.
To see this tested, let's turn to Mr. Green and his interesting garden.
Ah, Mr. Green.
Maple Street residents are complaining about Mr. Green's property. It's got overgrown weeds sprawling onto the pavement, attracting vermin.
Okay, classic problem.
And a collection of decaying garden gnomes that are, let's just say, creating an unsightly view.
Decaying gnomes.
Right. The council, having confirmed the conduct meets the criteria, serves Mr. Green a CPN. It requires him to 1. Clear all weeds within 7 days. 2. Remove all gnomes within 14 days.
Seems straightforward so far.
3. Install a 6-foot-high solid wood fence around the entire garden within 28 days. And 4. Attend a mandatory 3-hour horticultural course.
Ooh, okay. Now, the first two requirements, clearing weeds and removing those gnomes, seem perfectly reasonable for preventing or reducing the detrimental effect. That fits.
Right.
But that 6-foot fence and the mandatory horticultural course, those are definitely questionable under the reasonableness test.
How so?
Well, a fence could address the visual blight, perhaps, but demanding a specific height and material, a 6-foot solid wood fence might be seen as disproportionate or not directly necessary to prevent the detrimental effect from continuing.
Right, maybe a lower fence or just tidying up would be enough.
Exactly, and the horticultural course. Though perhaps helpful for Mr. Green in the long run, it might not be considered a reasonable requirement under the law for fixing the immediate problem, especially if the issue is simply neglect rather than a lack of gardening knowledge.
So it has to be directly aimed at stopping that specific detrimental effect.
Precisely. That's the core of Section 43.4.
So we've seen how CPNs are issued and what they can demand. But the law also builds in important safeguards to ensure they're applied fairly. What are those crucial steps authorities must follow before sending out a CPN?
Yes, there are definite procedural hoops authorities have to jump through. These are in subsections 5 to 8 of Section 43.
Okay.
First, and this is key, the individual or organization must receive a written warning that a CPN is coming if the conduct doesn't stop.
A written warning first, not just verbal.
No, must be written. And they also need to be given sufficient time to deal with the matter. Crucially, the detrimental conduct must still be happening after that warning period.
So a chance to sort it out themselves.
Correct. Second, before issuing the actual CPN, authorities should inform any appropriate parties they think relevant, like a landlord, if the CPN is going to a tenant.
Right, keep people in the loop.
Third, the CPN itself must clearly identify the specific conduct it's addressing. No vague statements allowed. It has to be precise.
Be specific, okay?
And finally, it's common and often necessary for the notice to include specific deadlines or timeframes for compliance.
Got it. Written warning, enough time, inform others, be specific, Set deadlines.
That's the checklist.
Let's apply those safeguards to the Night Owl Cafe situation. The cafe is a frequent spot for large, noisy groups gathering outside late at night, often leaving litter.
Familiar scenario.
B.C. Singh verbally told the manager, Mr. Khan, to sort it out, just verbally. 10 days later, after more complaints, P.C. Singh emailed Mr. Khan a formal CPN.
Okay, an email CPN.
It stated, "You are required to stop the antisocial behavior occurring outside your premises." That's it.
Bit vague.
It demanded Mr. Khan ensure no patrons gather after 11 p.m. effective immediately and install a commercial waste bin within 48 hours. P.C. Singh didn't give a written warning before sending the CPN, nor did he inform the local council's environmental health department.
Oof. Okay. P.C. Singh fell short on several counts here. Big time.
How so?
Well, first, the law requires a written warning, not just a verbal sort it out. That's section 43.5.
Okay, fail number 1.
Second, there was no sufficient time given for that immediate demand about patrons gathering after 11 p.m. That contradicts the spirit of giving time to comply.
Right, effective immediately doesn't sound like sufficient time.
Not at all. Third, the email's description of the conduct stop the antisocial behavior is far too vague. That violates section 43.7, needing specific conduct identified.
Too general.
Exactly. And fourth, he failed to inform the local council's environmental health department, which would certainly be an appropriate party under section 46, given the litter and noise issues.
So multiple procedural errors there.
Yes. This scenario really underlines that it's not just what authorities do, but how they do it that matters legally. The process is there for a reason.
Shifting gears a bit, responsibility isn't always about who's physically causing the antisocial behavior, is it? Section 44 seems to cast a wider net, especially concerning premises.
Yes, that's right. Section 44 makes it clear that if antisocial behavior happens on or impacts premises, the person who owns, leases, occupies, controls, operates, or maintains that property can potentially be held responsible for it.
So landlords, for instance.
Exactly. For example, a landlord could receive a CPN for their tenant's excessive noise because they ultimately have control over the property through the tenancy agreement, perhaps.
But there's a get-out clause, isn't there?
There is. A crucial exception in Section 4-2. A person's conduct isn't attributed to someone else, like the landlord, if that other person couldn't reasonably be expected to control or affect it. That's the key carve-out. Reasonably expected to control.
This brings us neatly to Mrs. Khan and her student tenants. Mrs. Khan owns a property leased to students, which has unfortunately become a hotspot for loud parties, public urination, rubbish dumping, you name it.
Oh dear. Nightmare neighbor scenario, but it's the tenants.
Right. Residents are suffering sleepless nights. Mrs. Khan, however, took no meaningful steps to control her tenants, insisting she doesn't live there, and therefore it's not her problem.
Trying to wash her hands of it.
The council served her, Mrs. Khan, a CPN, attributing the behavior to her as the lesser under Section 44. She challenges this, claiming she can't reasonably control independent adult tenants. What do you think?
Well, Mrs. Khan's argument hinges entirely on that reasonable control exception in 44.2.
Yeah.
While she's the lesser and initially covered by 44.1,
Yes.
the crucial bit from the source is that she took no meaningful steps. That really hurts her case.
Why?
Because the law expects property owners to take reasonable measures. Maybe through robust lease agreements, warning letters, active management, something to address such known issues.
So, because she could have done something, but didn't.
Precisely. Since she could reasonably have been expected to influence or control the situation, perhaps by threatening eviction under the tenancy terms but failed to do so, it's highly unlikely a court would agree with her claim that she shouldn't be held responsible.
It really highlights the responsibilities that come with being a landlord or property owner.
It absolutely does. You can't just collect rent and ignore the impact.
So, imagine you've received a CPN.
Yeah.
And you genuinely believe it's unjust or incorrect. Maybe the facts are wrong or the demands are unreasonable. What are your options? Can you fight it?
Yes, absolutely. The Act gives you a clear right to appeal under Section 46.
Okay, how does that work?
The law provides specific grounds to challenge a CPN in a magistrate's court. You can argue, for instance, 1, that the alleged conduct didn't happen, or it wasn't detrimental, or wasn't persistent or unreasonable.
The basic conditions weren't met.
Exactly. Or that it wasn't something you could reasonably control back to Section 4.3.2. 2, you can argue that any of the requirements in the notice or the deadlines given are themselves unreasonable, linking back to Section 4.3.4.
Right, the proportionality argument.
3, that there is a significant error or defect in the notice itself, like a wrong name or address maybe.
Technicality.
Or 4, that the notice was simply issued to the wrong person altogether.
Lots of grounds there. How long do you have?
You have a window of 21 days from receiving the CPN to lodge this appeal, so you need to act fairly quickly.
And what happens to the CPN while you're appealing? Does it get paused?
It depends. If the CPN told you to stop doing something, like stop the noise, that part generally remains in effect during the appeal.
But you still have to stop.
Usually, yes.
Yeah.
But if it demanded you do something like build a fence or clear rubbish, that requirement is typically paused until the court makes a decision.
That makes sense. And the court's options.
The court can look at the evidence and arguments and then either quash the notice entirely, basically cancel it or modify it, perhaps make the requirements less demanding, or simply dismiss your appeal if they think the CPN was justified.
Okay, let's consider Sarah and her garden wall. This scenario highlights appeals. Local youths gather near her wall. They're littering, shouting abuse, causing real problems.
Right. The problem is the youth's behavior.
But the council issues Sarah a CPN. It states the conduct is allowing your property to be used for antisocial behavior.
Phrasing it as her allowing it.
And it requires her to 1. Erect a 2-meter fence, 2. Install CCTV, and 3. Clear all litter daily. To top it off, the notice misspells her surname as Saeh, S-A-E-H. She receives it on May 1st.
Okay, Sarah has a really strong case for appeal here on multiple grounds under Section 46.
Such as?
Well, first, the notice arguably misidentifies the conduct as hers, allowing your property, when the issue is the youth's actions. She could strongly argue the behavior isn't something she can reasonably be expected to control or affect. That's Section 46(1)(e).
Right. She can't physically stop them, perhaps.
Second, those demands to erect a 2-meter fence and install CCTV. They are very likely to be seen as unreasonable requirements under 46(1)(2). Given she's not the source of the problem, it seems disproportionate to put that cost and burden on her.
Okay, unreasonable demands. What else?
Lastly, that misspelled surname, Saeh, instead of Sarah, is a clear material defect or error in the notice, falling under 46(1)(3).
So, multiple angles for appeal.
Definitely. And she has until May 22nd, 21 days from May 1st, to lodge that appeal. This case really demonstrates the importance of ensuring the CPN is accurate, proportionate, and directed at the correct party. You can see how appeals are vital.
Okay, what happens when a CPN is issued? It's valid, maybe the appeal failed or wasn't made, but the person just ignores it. They just don't do what it says. Does the local authority simply throw its hands up?
Not at all. The Act allows for direct remedial action in some cases under Section 47. They don't just give up.
Remedial action, what does that mean?
It means if someone, referred to as the defaulter, ignores a CPN, the local authority can indeed step in and sort the problem out themselves. But the process differs slightly depending on the type of property involved.
How so?
For open land, think a front garden, maybe an unfenced yard, or even a public park area affected the authority can directly carry out the necessary work. So if the CPN said clear rubbish from the front garden, they can go in, clear it.
And send the bill.
Exactly. They can then charge the defaulter for the reasonable cost of doing that work.
Okay, that's for open land. What about inside a house or a private business?
That's defined as other premises, basically, not land open to the air. For these places, the authority cannot just go in. They first have to issue another notice.
Another notice.
Yes, specifying the work they intend to do, its estimated cost, and crucially, inviting consent from both the defaulter and the property owner if they're different people. They can only proceed if that consent is given.
So they need permission for private property.
Correct. Once the work is done, whether on open land or other premises with consent, the authority issues a bill demanding payment. The defaulter is liable for the reasonable costs.
Can you challenge the bill if you think it's too high?
Yes, you can. Section 47, 7, and 8 allow the defaulter to appeal the amount demanded to a magistrate's court within 21 days if they believe the cost is excessive.
Okay, let's look at Brian's situation with Section 47. He received a CPN to clear rubbish from his front garden that's open land within 14 days.
Right.
And also to repair a broken ground floor window, which is other premises, within 28 days. Brian ignored both requirements.
Okay, typical noncompliance.
After 30 days, the authority came and cleared his garden. They also sent him a notice about the window repair, estimating it at £300 and inviting his consent. Brian explicitly refused consent for the window repair.
He said no.
But the authority proceeded with the window repair anyway. Later, they billed him £150 for the garden clearance and £400 for the window repair, which was higher than their estimate.
Okay, interesting split here. For the front garden, which is open land, the authority was within its rights under Section 47(2) to carry out the work directly. So Brian is on the hook for that £150, assuming it's a reasonable cost.
Right. The garden part is straightforward.
Yeah.
But the window?
But for the window repair, which is other premises, the authority needed Brian's consent under Section 47(3). Since Brian explicitly refused consent, the authority was not entitled to go ahead with that repair.
So they can't charge him.
They cannot recover the £400 from him for the window. He didn't consent. This highlights a critical distinction in the law and a safeguard for private property rights. Brian can certainly appeal that £400 charge, and he should win.
So there are costs involved if the council have to step in. But ignoring a CPN isn't just about money, is it? There are also criminal consequences. Section 48 makes it a definite offense.
It absolutely does. Failing to comply with the CPN without a reasonable excuse is a criminal offense under Section 48(1).
And what are the penalties?
The penalties can be quite significant. For individuals, it's a fine up to level 4 on the standard scale. Currently, that's £2,500.
£2,500. Okay.
For organizations like businesses or charities, the fine can go much higher, up to £20,000.
Wow, £20,000. That's serious. Are there any defenses?
Yes, there are defenses specified in Section 48(3). You won't be found guilty if you can prove you took all reasonable steps to comply with the notice.
Tried your best, basically.
Essentially, yes. Or if you had some other reasonable excuse for the failure to comply.
That reasonable excuse defense is interesting. Does that phrase have a specific legal meaning? Or is it judged case by case?
It's generally judged on the facts of the specific case. It sets a fairly high bar, though. It's not just any excuse. It has to be genuinely reasonable in the eyes of the court.
Would it cover Greenfields Ltd. in this scenario? They had a CPN requiring them to cease noisy operations, specifically loading and unloading between 8 p.m. and 7 a.m.
Right, clear time restrictions.
A week later, they were observed unloading noisy steel girders at 6:30 a.m., clearly breaching the notice. The site manager explained their main delivery driver was unexpectedly sick, and the only replacement driver available could only deliver at that time. He cited a crucial project deadline as the reason they accepted the delivery.
Okay, so Greenfields Ltd. Definitely committed the offense under 48(1) by breaching the CPN's time restriction. No doubt about that.
But do they have a reasonable excuse?
Well, that's the question for the court under 48, Lee. An unexpected sick driver and a project deadline are certainly challenges. Business pressures are real. But a court would meticulously examine whether all reasonable steps were genuinely taken to avoid the breach.
Like what?
Could they have rescheduled the delivery for later in the day after 7 a.m.? Could they have used quieter methods, if possible? Could they have anticipated driver sickness better?
So it's a high bar.
It is. Simply being inconvenienced or facing a deadline, while difficult, might not be enough on its own to satisfy the reasonable excuse defense. It really boils down to diligence and foresight in trying to comply.
So conviction is a real possibility. If someone is convicted under Section 48 for failing to comply, the court isn't just handing out fines and calling it a day, right? It has powers to ensure the original problem actually gets fixed. Section 49 covers remedial orders.
Exactly. A conviction isn't necessarily the end of the story regarding the original issue. After a Section 48 conviction, Section 49 empowers the court to make any order it thinks appropriate to ensure the CPN's original requirements are finally fulfilled.
Any order it thinks appropriate, that sounds very broad.
It is broad. Section 49 gives wide discretion, but subsection 2 gives specific examples. The court can order the defendant themselves to carry out specific work needed to comply with the original CPN.
Force them to do it.
Or, alternatively, order them to allow the local authority to come onto their property and carry out the necessary work on their behalf. It's about ensuring the underlying issue that prompted the CPN is finally addressed, not just punishing the breach.
Let's consider Barry's situation with Section 49. He accumulated a load of scrap metal and other waste in his front garden. He ignored a CPN telling him to clear it. He was then prosecuted under Section 48 and convicted. But the rubbish, unfortunately, still remains there after the conviction.
Classic case. Convicted, but the problem persists.
So what can the court do now under Section 49?
Following Barry's conviction, the court has that broad authority under 49(1). More specifically, using 49.2, the court could order Barry himself to carry out the specified work of clearing all that waste, setting a deadline perhaps, or perhaps more effectively, if Barry is still unwilling, the court could order him to permit or allow the local authority to enter his property and carry out the clearance on his behalf. This provides a direct and legally backed path to finally resolve the problem.
So the court ensures compliance one way or another.
That's the goal of Section 49.
And sometimes it's not just about doing work, but the court can actually take away the items used to commit the offense. Section 50 covers the forfeiture of items.
Yes, this is another powerful tool for the court post-conviction. Section 51 allows a court to order the confiscation, the forfeiture, of any item that was used in committing the Section 48 offense, the breach of the CPN.
Any item? Like what?
Well, it depends on the breach. If the breach involves, say, fly tipping from a vehicle, maybe the vehicle. If it involved noise, maybe the sound equipment.
And what happens to the confiscated item?
Section 52 says the court can order the item to be handed over to a police officer or a person authorized by the local authority. And then under Section 53, the court can order that item to be destroyed or disposed of in any way it specifies.
Wow, destroyed even.
Yes. It's a direct way to prevent future offenses using the same means and removes the tools used for the breach. What's fascinating here is how punitive it can be, taking away potentially valuable property to enforce compliance and prevent recurrence.
Raj and his loudspeaker system seems like a perfect example for Section 50. Raj repeatedly played loud music from powerful speakers, constantly disturbing neighbors, despite having a CPN prohibiting amplified music after 10 p.m.
Clear breach.
He ignored it, was prosecuted and convicted under Section 48. He still has the speaker system set up in his house.
Okay, so given Raj's conviction under Section 48 for using that specific speaker system in breach of the CPN, the court absolutely does have the power under Section 51 to order the forfeiture of his speaker system.
So they could take his speakers away.
Yes. The order could require Raj to hand the speakers over to a constable or an authorized local authority person, as per 52, and then the court could order their destruction or disposal under 53. It's a very direct form of intervention to stop that particular nuisance recurring.
A clear consequence. Now, we've talked about court action, but not every CPN breach ends up there, does it? For less serious failures to comply, there's a quicker, sort of on-the-spot option. The fixed penalty notice, or FPN, under Section 52.
That's right. An FPN, similar to ones you might get for littering or some parking offenses, offers an individual a chance to discharge their liability for the Section 48 offense breaching the CPN by simply paying a fixed penalty amount.
So pay up and avoid court.
Essentially, yes. It avoids a criminal conviction. It's designed for efficiency in less serious cases.
Is there a limit on the fine?
Yes. Section 52.5 specifies that the penalty amount stated in an FPN cannot be more than £100.
£100 maximum. And what information has to be on the FPN itself?
Section 52.4 is clear on this. It must include reasonably detailed particulars of the circumstances of the alleged offense. It needs to state the exact penalty amount, the period for payment, usually 28 days, and clear instructions on where and how to pay it.
So all the key details need to be there.
Absolutely. It's a formal notice, even if it's avoiding court.
Let's look at Sarah and her dog Buster with Section 52. Sarah had a CPN requiring her to keep her dog Buster on a lead in a designated area of the local park. Pretty specific.
Okay. Common requirement in parks.
PC Collins, who is an authorized person, observed Sarah letting Buster run freely in that designated on-lead area, clearly breaching the CPN. PC Collins decides to issue an FPN instead of prosecuting.
Right, using the quicker option.
He issues an FPN for £80, payable to the local council within 28 days. It provides the council's address and payment methods. The notice briefly describes the incident as dog off lead in designated area.
Okay. So PC Collins, as a constable, is definitely an authorized person under Section 52.1 and 2, and also Section 53, which we'll get to. He can issue FPNs.
Right.
The purpose of the FPN, as per 52.3, is exactly as we said. Give Sarah the opportunity to avoid conviction by paying the £80 fine. If she pays within the 28 days, her liability for conviction is discharged.
And the amount.
The £80 penalty does comply with Section 52.5, as it's not more than £100, so that's fine.
But is there a potential issue?
Well, possibly with the description. The FPN's description, dog off lead in designated area, is quite brief. Section 52.4 requires reasonably detailed particulars of the circumstances.
And that might not be detailed enough.
It could be argued it's insufficient if it lacks specific details readily apparent from the CPN itself, like the exact date, time, and maybe the specific designated area within the park if there are multiple. It's a reminder that even these simpler notices need precision to be fully robust against a challenge.
Good point. Okay, finally, we've talked a lot throughout this about authorized persons. Who exactly gets that title under the Act? Section 53 clarifies this, doesn't it?
Yes, Section 53 defines who has the power to issue CPNs under Section 43 and FPNs under Section 52.
So who's on the list?
It's quite specific. First, constables, so police officers of any rank.
Police, got it.
Second, the relevant local authority. This essentially means the local council for the specific geographical area where the antisocial behavior for issuing a CPN or the offense of breaching a CPN for issuing an FPN took place.
The council itself.
Yes. And third, and this is important for flexibility, a person designated by the relevant local authority.
Designated, what does that mean?
This allows councils to formally authorize other individuals to issue these notices on their behalf. This could be specific council officers who deal with environmental health or community safety, for example.
So not just any council worker.
No, they have to be specifically designated for this purpose under Section 531C. It can even include employees of partner organizations the council works with, like registered social landlords or housing associations, if the council formally designates them.
So it allows councils to delegate this power.
Exactly. It broadens the range of officials who can tackle these issues directly on the ground.
Let's look at our final scenario then, on Elm Street, focusing on Section 53. Residents complain to any town council about persistent noise coming from Mr. and Mrs. Jones's property.
Okay.
PC Adams attends and witnesses the noise himself. Separately, Ms. Patel, who works for any town council as an environmental health officer but has not been formally designated under Section 53, also visits the property about the noise.
Right. One police, one council officer, but not designated.
Later, Mr. Khan, who is an employee of any town housing association, and this association has been formally designated by any town council under Section 53(1)(c), observes Mr. Jones breaching a different, previously issued CPN that required him to keep his garden tidy. Mr. Khan considers issuing an FPN for this breach.
Okay, this scenario is a great wrap-up because it perfectly highlights the nuances of who has the power under Section 53.
So break it down. Who can do what?
Right. PC Adams, as a constable, Section 53(1)(a), is an authorized person. He could issue a CPN regarding the noise he witnessed.
Okay, police are authorized.
Ms. Patel, however, despite being a council environmental health officer, is not an authorized person to issue a CPN for the noise because she has not been formally designated by any town council for that specific purpose under 53(1)(c). Her job title alone isn't enough.
So designation is key for council staff.
It is, but now look at Mr. Khan. He works for the housing association, not the council directly. However, because his housing association has been formally designated by any town council under 53(1)(c), Mr. Khan is an authorized person.
So he can issue the FPN.
Yes, he is authorized to issue an FPN to Mr. Jones for breaching the existing CPN about the tidy garden. This really underlines that designation isn't automatic based on job role. It requires an explicit formal act of designation from the relevant local authority.
Wow, that was a truly comprehensive look at the Community Protection Notice.
Yeah.
Definitely one of the most impactful tools within that whole Anti-Social Behaviour Crime and Policing Act 2014.
It really is.
We've seen how this act provides, well, a pretty robust toolkit for authorities to tackle everything from noisy parties right through to neglected properties. It really is the local lever for public order, isn't it?
It really demonstrates a very multifaceted approach, trying to ensure public safety and quality of life. It's about giving authorities the muscle to step in when needed,
Right.
but also trying to make sure that there are clear rules, procedural safeguards, and importantly, ways for people to challenge those decisions if they think they're wrong.
So it's not just a blunt instrument.
No, it's intended at least to have built-in checks and balances. Thinking about it, knowledge is most valuable when it's understood and can be applied to real-world situations like these.
So what does this all mean for you listening? Well, understanding these powers and also their limitations can really empower you. It can help you advocate for your community if you're facing persistent issues. It helps you know your rights if you ever find yourself on the receiving end of a CPN.
Absolutely. Know the process, know the grounds for appeal.
Or, simply appreciate the complexities involved in maintaining public order in your neighborhood. It really highlights that constant tension, that fine line between individual freedom and community responsibility.
That's a good way to put it.
And how the law tries, sometimes successfully, sometimes perhaps less so, to manage that delicate balance.
A constant balancing act.
Thank you so much for joining us on this deep dive. Until next time, keep digging for those insights.